What happens if someone dies without a will? Hi, I'm Alec Osland, an attorney at Yanowitz Law Firm, where we've been assisting families for 30 years with wills, trusts, and probate. What happens if someone dies and they don't have a will? Where do their assets go? These are questions I get asked a lot in practice. And my answer to that is it's always that famous attorney answer of, it depends. It's going to depend on family dynamic, the family structure, with how those assets are going to pass. And what I mean by that is we actually have to look at statute to figure out how the assets are going to pass. Even if someone doesn't have a will or a trust, they technically do have an estate plan. It's just their estate plan is what is the Minnesota statute says. So the Minnesota statute that governs how assets pass if someone does not have an estate plan is referred to as the Minnesota laws of intestacy. And so depending on how that family structure is set up, that's going to govern how the assets are going to pass. For example, if someone passes away without a will or a trust and they have a surviving spouse and they have no children, all of those assets are going to go to the surviving spouse. If someone passes away and they don't have a surviving spouse, but they have children, all of their assets are going to go to their children. Now, when we think about children, we want to be very specific with who we're referring to. Under Minnesota law, children are going to inherit under this statute if they are a biological child of the decedent. Also, if they are formally adopted by the decedent, then they will also inherit. So Minnesota law looks at biological and adopted children the same. Also, it looks at half siblings the same as well. If they had a different mom, but the same dad, and dad passed away and didn't have a surviving spouse, they're going to inherit because they are dad's child. So stepchildren, though, are not considered a biological child, so they would not inherit in this situation unless they were formally adopted by the decedent. Where things get a little more complicated is if we have a surviving spouse and then there are children from a prior relationship. In that situation, the surviving spouse is going to get the first $225,000. The remainder of the assets then are split 50-50, with 50% going to the surviving spouse and the other 50% going to the children who are not a descendant of the surviving spouse. Now, that surviving spouse does also get some rights with the homestead as well for a place to live. But with just looking at the overall cash distributions, the math is pretty straightforward. Of the surviving spouse gets the first $225,000, and then everything else is split 50-50, with that 50% chunk going to the surviving spouse and the other 50% going to the descendants of the deceased who are not a descendant of the surviving spouse. So if there's 5 children, they are essentially each going to get 10% of that remainder, while that surviving spouse gets the 50% of the remainder after that first $225,000. Now, with these distributions, there's no restrictions on how the assets are being conveyed out. So a lot of times with the estate plans that I draft in wills or trusts, we're adding certain restrictions where we want to make sure a beneficiary is a certain age before they get their inheritance, because generally we don't want an 18-year-old to end up with a bunch of money. We want to kind of protect it because they may not utilize the funds in the best way. So if we don't have an estate plan and we're relying on these laws of intestacy, we're not really getting any protection with this money with how things are going to be used. With that estate plan, we're generally doing it for 2 reasons. One, we want to identify where our assets are going. And 2, we want to identify who's in charge of handling the assets and making sure they end up there. If we're relying on the laws of intestacy, we're not doing either of those. We're following the statute which says where our assets are going, and then we're also following a statute which identifies who can serve as personal representative. When we think about where we want our assets to go, we want to make sure that you meet with an attorney, have a will or a trust drawn up so you can be specific with where your assets are going. Depending on the family structure, some of the examples that I gave might not even be applicable. Where if, say, for example, there's no surviving spouse and there's also no children. In that situation, the assets are going to go back up to the parents. And then if their parents aren't living, then it's going to go to the descendants of the parents. So you can kind of think of it kind of up and out the family tree if there's no descendants. What I'm trying to get here, though, is a lot of times when we pass away, we're leaving on our legacy. We're identifying generally where our assets want to go. So if we want to leave them to certain family members, certain friends, or if we want to make sure that certain family members or friends don't get certain assets, it's very important that you have an estate plan so you can articulate where everything should go. If you'd like to learn more about estate planning, make sure that you subscribe to our channel to find out when we post a new video. Thanks. Have a great day.